Every day for decades, U.S. Postal Service letter carriers deliver mail to millions of homes in every kind of weather. Then, in 2016, in June, the U.S. experienced a particularly severe heat wave. In Benton, Arkansas, a letter carrier for the U.S. Postal Service was delivering mail on his route. It was hot that day, and he began to feel sick. His head began spinning, and then he began to stumble along his route and started vomiting. He staggered back to his van and collapsed. A neighbor found him sometime later and called 911, and he was sent to a hospital. Far away, near the Houston Astrodome, another letter carrier was hospitalized that same week after he suffered heat-related illness in the same heat wave. He was checked into a hospital for 2 nights and was unable to return to work for 9 days. That same summer, around the nation, several other letter carriers also suffered from recordable heat stress cases in San Antonio, Des Moines, Martinsburg, West Virginia, and OSHA conducted inspections and issued citations under the General Duty Clause. By today, almost 7 years later, the Occupational Safety and Health Review Commission has conducted hearings, reviewed a mountain of evidence, and issued an opinion. This opinion will have an effect on employers across the nation as they deal with one of the most ubiquitous environmental factors in the workplace, heat. I'm Manesh Rath, and this will be the topic of our discussion today, March 22nd, 2023, on the OSHA 3030. Hello, friends, and welcome to the OSHA 3030, a webinar and podcast covering updates on OSHA law every 30 days. We've been doing this program for almost 10 years, and there are over 100 episodes on our website, so please check them out. Every month, we republish this webinar as a podcast and on YouTube. So just search on either OSHA 3030 or Manesh Rath, and you'll find them. This program is complimentary to clients and friends of Keller and Heckman, and the only thing we ask in return is when you receive an email inviting you to the next month's program, to please forward it on to at least 3 colleagues in your Office of General Counsel or your safety and health professionals at your organization. As I said, I'm Manesh Rath. I'm an attorney at the law firm Keller and Heckman here in Washington, D.C. And I'm grateful because today I'm joined by my dear friend and colleague, Taylor Johnson, one of the stars of our OSHA law practice here at Keller and Heckman. Taylor, welcome, and thank you for joining us on the OSHA 3030.
Well, thanks for having me as always, Manish.
Well, we've got an important topic today. Why don't we get into what we're going to talk about, something that affects everyone, heat. So let's get into what we're going to talk about today.
Right. So for today's agenda, we're going to start with the factual background of the case that we're going to be covering. This is Secretary of Labor versus the United States Postal Service. Then we'll go into the elements of the General Duty Clause, which is what the Postal Service was cited under in this case. We'll go through the ALJ's decision, and then importantly, we'll unpack the Review Commission's decision. We'll then move to an update on the federal heat stress standard, and as well as a national emphasis program. So 2 elements there that we wanted to bring to everyone's attention. And then, as always, we'll wrap up with what employers should do, some practical takeaway action items for you to bring back to your workplace.
That's right. And this program is being pre-recorded, so we usually end with a live session for the webinar participants only, where they can ask questions, pre-submit questions, or ask them live in the chat function. And it's just a great informal off-the-record session. We're not doing that today because we're pre-recording it on Monday, March 20th, for the Wednesday, March 22nd episode of the OSHA 3030. So we'll skip that section today, get into the facts. The facts of this case really emanate from 5 different cases. In the summer of 2016, several mail carriers in cities around the nation experienced symptoms of heat illness, such as headaches, nausea, vomiting, dizziness, muscle cramps, and several of them collapsed on their routes. So severe cases of heat stress.
That's right. And the cities, the 5 cities listed are San Antonio, Texas, Benton, Arkansas, Houston, Texas, Martinsburg, West Virginia, and Des Moines, Iowa. All 5 cities, as we mentioned, these all occurred in one summer of 2016. I believe, Anish, actually, that it was the hottest year on record, at the time. And so we sort of saw this, happening all across the country.
At the time, it was the hottest year on record. That's right. It's tied now with the year 2020. But in June, which was very early for a heat wave, there was we experienced severe temperatures all across the country. In Palm Springs, California, it hit 122 degrees. In Tucson, it hit 120 degrees, 126 in Death Valley, and it goes on and on. And these cases, San Antonio, Benton, Arkansas, Houston, Texas, are certainly in the Sun Belt to an extent, but you can't necessarily say that about Des Moines or Martinsburg, West Virginia, where they're also experiencing severe heat waves. So an exceptional circumstance, to be sure, but that really forms the basis of one of the questions the administrative law judge had to address: is how severe would the heat have to be to qualify as excessive heat under OSHA's general duty clause? We'll talk about that. So what happened was, when these 5 incidents happened, several of them were sent to hospital, and that triggers a self-reporting duty for the employer. Something employers need to remember and to train their facility managers about is that when there's a hospitalization requiring care and an overnight stay, that's something you have to self-report to the Occupational Safety and Health Administration. And so that's what happened. And the Occupational Safety and Health Administration conducted investigations, ultimately issuing citations under the general duty clause.
The specific allegation was that the Postal Service allegedly exposed workers to the hazard of excessive heat while walking and hand delivering mail in an outdoor environment. Excessive heat becomes this very important term in the case as we move forward. And then the penalties for the alleged violations ranging from $124,000 down to $68,000, a total across the 5 cases, over $500,000 in penalties here.
Yeah, that's right, Taylor. So the penalties are significant, but again, as with so many cases that we've covered, you and I, Taylor, in the OSHA 3030, it's really the abatement that would have to be implemented by an employer,
right,
that can sometimes far outsize the cost of the abatement would far outsize the cost of the penalties themselves. And I think that's clearly what would happen here. So OSHA proposed specific abatements, and they required that they be implemented enterprise-wide. OSHA and the United States Postal Service engaged in negotiations to try and come up with a solution that might be amenable to all. Those negotiations failed, and the Postal Service contested the citations. And that began the contest that went to the administrative law judge and ultimately then to the review commission for review.
That's right. So as we mentioned, the Secretary issued 5 citations to the Postal Service, all under the General Duty Clause. We wanted to point out here that OSHA plans to initiate a rulemaking process for a federal heat stress standard, but that did not exist yet at the time, so that's why these came under the General Duty Clause.
That's a great point, Taylor. And when you issue as we've covered again many times in prior episodes of the OSHA 3030, when you issue a citation under the General Duty Clause, the agency has a slightly higher burden than when it issues a citation under a specific standard, alleging a violation of a specific standard. With the General Duty Clause, there's 4 prima facie elements that it has to establish, and it has to establish all 4 of them: that there was a hazard that was recognized, that employees were exposed to that hazard. There has to be exposure, without which there isn't a General Duty Clause violation. Taylor?
That's right. And then the next being that the hazard caused harm and that the hazard could be abated. And so all 4 of these really were, gone through in great detail by the review commission in this case.
Now there's nuance to all of them. When you talk about the idea that the hazard was a recognized hazard, it could have been recognized by the employer or could have been generally recognized by the industry. The idea of causing harm, it could have been reasonably foreseeable that it could cause harm. We're talking about a fatality or a severe illness. And so there's nuances to all these, but we wanted to cover the basics of the General Duty Clause just to make sure everyone is caught up with that principle, so that you understand the debate that takes place both before the administrative law judge in extensive hearings as well as before the review commission. Okay, so then the case goes to the administrative law judge. He conducts a hearing and examines massive amounts of evidentiary presentation, including many expert witnesses testifying on both sides.
That's right. Eventually issues 5 separate decisions. The key point here being that all 5 citations were vacated by the ALJ on the basis that OSHA presented insufficient evidence as to how to define the amount of heat exposure that qualifies as a recognized hazard. And this is really one of the points that the Review Commission goes into great detail on. OSHA's expert opinions, according to the ALJ, were based almost solely on this National Weather Service chart that in the ALJ's opinion did not have a scientific basis. But that's gone through, like I said, in great detail by the Review Commission.
Yeah, it's a good point, Taylor. I mean, when you look at the National Weather Service chart, it looks like it gives clarity, but the question that the parties examined before the administrative law judges, what was the evidence that the National Weather Service used to develop the thresholds or the sort of stoichiometric boundaries between one level of a heat index and another, and where it described a red zone of extreme danger, where it described what was the threshold and why, what evidence supported the threshold for the orange zone of danger, et cetera, extreme caution and caution. And so the administrative law judge found that OSHA had presented very poor evidence to support the National Weather Service's chart, heat index chart. And for a while, this case stood for the proposition that the National Weather Service chart should not be used to determine, either by the agency when issuing general duty class citations or by employers when promulgating their own internal heat stress management plans, and should not be used as sort of the sole method by which these kind of external forces are measured upon an employee, or a worker. So I think that that's one of the important takeaways, is that the National Weather Service chart was maybe discredited, or at least found to be based on insufficient evidence. And then the Review Commission reviewed this case again more recently.
Right.
And that's one of the issues that they took up.
Yeah. And certainly very important for OSHA. We get into the later we get into the national emphasis program on heat, but the National Weather Service, chart is one of the one of the bases that OSHA uses in its national emphasis program for conducting inspections. So there was definitely sort of a cause for concern when its scientific credibility was brought into question.
Right. Whereas other regulatory paradigms don't, like California's, for instance. The other issue that they addressed is the question of whether or not there exists a feasible means to abate the alleged hazard. And by feasible, the courts have always parsed that out into technically feasible or technologically feasible and economically feasible. And so OSHA would have been required to present evidence that there was some technical and economically feasible means of addressing what it alleged to be a general duty clause hazard for excessive heat. So then the case, after the ALJ vacates these citations, it goes up to the Review Commission to review, and they just issued their decision recently.
That's right. They consolidated 4 of the 5 cases and vacated all 4 citations. The key point of disagreement between the Review Commission and the ALJ is that the Commission found that the Secretary did prove the existence of a hazard. But Manesh, they ended up agreeing with the ALJ with respect to the feasible and effective means of abatement.
Right. What they didn't say was that OSHA had established that there was a hazard by use of the National Weather Service chart. What they said was, well, when you look at all the expert testimony, the experts didn't rely solely on the NWS chart. They had their own testimonial evidence that the environmental exposure for these letter carriers did constitute, in their professional opinion, their expert opinion, did constitute excessive heat on those particular circumstances. So that it wouldn't be necessary to rely on the National Weather Service methodology for determining what would and would not qualify as excessive heat. So that part gets sent aside, and that original premise used by the administrative law judge is no longer sound law, and that's a sort of radical departure from the ALJ's decision, which many people had relied on for a while. Then there comes the question, as you say, Taylor, about so the agency says, yeah, we think that there was testimonial evidence sufficient to show that there was an excessive heat hazard. Now we address the question of whether or not there was a feasible means of abatement, technical feasibility and economic feasibility.
Just to go quickly back to hazard. So the secretary must prove a significant risk or meaningful possibility that the workplace conditions would harm employees. And then to prove this, the secretary must show environmental and then metabolic heat conditions, which subjected the carriers to significant risk of experiencing a heat-related illness or injury.
Yeah, there's a lot of factors that go into why most people in a given set of circumstances don't feel the effects of heat stress, and then some people do. And the temperature itself is one of many factors. The humidity or the heat index, the acclimatization of the worker to working in heat, the amount of work being performed, clothing, dehydration or hydration, and general physical conditioning of the worker all are confounding variables when trying to determine what is an in excess level of heat load for that worker.
Right.
As well as, of course, time, which I forgot, the time of exposure or duration of exposure.
And then as you mentioned,
yeah, go ahead, Taylor.
Just, as you mentioned, with respect to the National Weather Service chart, the review commission finds that OSHA experts consulted the chart, but did not exclusively rely on it. It was kind of cut under one of the ALJ's, key points. And then we end up concluding, the review commission does, that the witnesses did support a finding that environmental and metabolic heat conditions were present, that were hazardous. So that, sort of first box of the general duty clause, then the review commission says that the secretary met the burden there.
Yeah, based on expert witness testimony. So then they have to address the question of feasibility. The agency tried to establish that there were many means of abating the hazard, including training workers and supervisors. But then they listed a catalog of other means by which the Postal Service could have abated the hazard of excessive heat exposure.
Right. That's right. And so eventually the secretary, the review commission finds that the secretary did not establish this economic feasibility threshold, sort of rejected OSHA's reliance on the Postal Service's cost estimates because estimates are not reflective of proposed abatement measures. There was also a problem with the Postal Service putting on this evidence that it was facing a looming financial crisis. OSHA starts to get into these arguments, essentially saying that because the Postal Service is a quasi-government agency, it's too big to fail. But the review commission didn't agree with that point.
Right. And Taylor, a part of that, it's important to understand what some of the proposed abatement methods were that OSHA was suggesting that the Postal Service undertake. One, for example, would have been implementing periodic breaks. Instead of 5-minute breaks, maybe expanding them to 15-minute breaks. One might have been that they hire more letter carriers and shorten the routes, thereby shortening the exposure time. Another was air-conditioned vehicles for every letter carrier. Right now, almost all of the letter carrier vehicles are open vehicles so that letter carriers can come in and out of the vehicle quickly, which would shorten their overall shift theoretically. And that the number of times, the frequency with which, and the duration of which the door has to be open would render air conditioning theoretically ineffective to cooling the interior of the cabin anyways. So there were a lot of proposals that OSHA came up with, and there were a lot of logistical reasons that the Postal Service explained why these wouldn't work. They started with an explanation of the process that the mail goes through when it arrives at a station, gets sorted, and then collected by the carrier and put in order of his route, and then he goes on his route or she goes on her route and does the delivery. And they pointed out that a lot of the proposed changes that OSHA was suggesting or ordering as abatement were infeasible because the time it takes for that mail to go through that process would have been disrupted. And that the disruption is a multiplier as you go down the line in that process. So a small change to the carefully orchestrated process for how mail gets delivered, routed, distributed, and then sorted and then delivered would have what they referred to as a bullwhip effect down at the end of the line, that a few minutes here and there periodically would result in 15, 20, 30 minutes or hours longer on every letter carrier's route. And again, the bullwhip effect theoretically would apply when you look at the large size of the fleet. A small change to a vehicle would lead to a large cost impact across the entire fleet. This was a nationwide abatement. But at any rate, there are logistical problems like the one I described with the vehicles, where you simply can't air condition them, and then leave the door open and closed constantly as a letter carrier entered and exited, sufficient to deliver the mail. And there's at least two types of letter carrier: one who's getting in and out of his vehicle to deliver door to door, and then one on, like, for example, rural routes where they drive up to the mailbox and their window is always open so that they can just reach out and put mail in the mailbox, and air conditioning is an insufficient sort of abatement in that kind of context. So a lot of logistical problems that the Postal Service put tremendous amount of evidence into debunking OSHA's suggestions. Ultimately, as you say, Taylor, it came to the question, when you look at large scale abatements like air conditioning of vehicles, as to whether the U.S. Postal Service had enough money to do so across its nationwide fleet, and pointed to the fact that as we speak, the Postal Service is running at a loss, and that large scale costly abatements like the ones OSHA was proposing would exacerbate those costs to the point where it may jeopardize the survivability of the Postal Service. Interestingly, OSHA's response was that the Postal Service is too big to fail. Congress is obliged to financially backstop the Postal Service, and so it couldn't fail, something that the Review Commission, as an argument, rejected.
So it's a little bit on the economic feasibility. Also, just real quick on the effective means of abatement. One of the things that the Review Commission looked at was the Postal Service's existing emergency response plans and monitoring, and actually found that the measures that OSHA was suggesting with respect to those would not materially reduce the hazard beyond what the Postal Service already had in place. So that was one interesting finding as well in terms of the effective means of abatement.
Right. Everything down to the training requirements that OSHA had ordered. They found that in that case, the training would not have materially affected safety, and that there was a training program. There was one instance where a manager had not been trained, but overall, the Postal Service had a training program, and any changes to it, OSHA couldn't establish that would have had an abatement-like effect. So the enormous amount of discussion on every single one of OSHA's suggestions, and ultimately the Review Commission found that there wasn't sufficient evidentiary support for it, or that there were good countervailing arguments by the Postal Service as to why they weren't feasible. Taylor, there was one interesting footnote in the opinion.
Yeah. So a footnote by Commissioner Lehau, stating that just this term excessive heat is vague, and that the lack of clarity makes it difficult for employers to know what heat conditions moving forward the Secretary will treat as excessive heat. So I think essentially saying that that this is what excessive heat looked like in this particular instance, but that moving forward is still a little bit unclear for the employer community.
Right. I think what Commissioner Lehau was saying was that this is that when you look at the specifics of this testimonial evidence based on the circumstances in those 5 cities, those 5 cases, that there was that the agency had established that excessive heat was present, and that OSHA would have to present that particularized evidentiary basis for asserting that there was excessive heat in each case, because that's required under the General Duty Clause. Given that it's not generally recognized as to what is and is not excessive heat, in light of all the confounding factors like hydration, conditioning, acclimatization, etc., and the workload itself. And so that now presents the state of the law with respect to use of the General Duty Clause in heat stress cases. The commissioner did note in that same footnote that she was aware that OSHA had announced its intent to engage in rulemaking. So it's perhaps possible that one day very soon we will have a brand new OSHA standard that is specific to heat stress. And indeed, they've stated their intention for a number of years now, and there are many who believe that the finalization of the rulemaking is now more imminent than it ever has been. In the meantime, OSHA has a national emphasis program.
That's right. So National Emphasis Program for outdoor and indoor heat related hazards. This has been in effect since April 8th of 2022 and will continue for at least the next 2 years until April of 2025. Various elements to this National Emphasis Program, including targeting high risk industries, setting up neutral and objective selection criteria for conducting inspections, and a few more, Manesh, as well.
Yeah, it describes how OSHA should select facilities to conduct a heat stress or inspection, and it points to the 70 odd industries that it considers to be high risk, and as you pointed out, construction and agriculture clearly. But it also points to the use of complaints, site-specific targeting, and fatalities or catastrophes-based inspections to tie in to their national emphasis program on heat as well. And on those occasions, to conduct heat-related inquiries with respect to their national emphasis program at that establishment that they may have been brought into for associated or other reasons.
Right. And then, pre-planned inspections of these high-risk industries, as well as when a heat priority day, which is when the heat index is expected to be 80 degrees or higher, or when the National Weather Service has announced a heat warning or advisory for that local area, inspections triggered based on those conditions.
Yeah, and some of the questions you can expect out of a national emphasis program based inquiry by the inspector would be to take a look at your OSHA 300 and to see what incidents you may have had with respect to a possible introduction of heat as an environmental stressor. They'll probably ask about training programs, and they'll ask about what protocols are being put into place to manage heat stress on high heat days. For example, breaks, the availability, the close proximity of water and shade for breaks. And I think that those will be the bases on which OSHA will determine whether or not to issue citations when conducting national emphasis program based inquiries in its inspections. You may also see their letters of inquiry ask those same questions to supply us data relating to your Form 300 or training or your protocols if you have written protocols. So keep an eye out for that.
Just a real quick update on the federal heat stress standard that we wanted to give. So really the update at this point is that it's still in a holding pattern. No decisions have been made by the agency on either the content or the timing for proposed rule. But there is an upcoming SBREFA review that should happen sometime this year. And then I think 7 states petitioned OSHA for an emergency heat danger rule in February of 2023. But a lot of just kind of waiting at this point as to what could be in this rule.
Right. So we got about a minute left, Taylor. Let's talk about what employers should do in light of this recent and incredibly important review commission decision. I think the first thing to do is to take a look at each company should take a look at its own protocols for addressing high heat days. What is their plan of action, and is it written, and does it start with a hazard assessment?
Absolutely. And then acclimatization programs for employees who are new to working in these warm environments, making sure that you're sort of slowly ramping them up. I think this is certainly one of the areas where we see the most heat related injuries and illnesses with these new employees.
Right. And to consider changing their shift times on high heat days is something that we've seen. We did an OSHA 3030 program where we brought in a safety and health professional who works in construction on the water, on construction docks and floating platforms. And they, on high heat days, start super early so that they can wrap up before the hottest hours of the day. Another thing that I think OSHA is going to be looking for during its inspections.
Absolutely. And then as to when these inspections might occur, as we mentioned, with respect to the national emphasis program, certainly expect increased inspections on days when the heat index is above 80 degrees.
Right. Finally, if any employer is faced with a general duty clause citation or even an inspection, then I think that it's important to examine what OSHA's ordering as an abatement, and I should say proposing as an abatement, because there is going to be a challenge for the agency up until a rule is promulgated and in effect under the general duty clause in establishing whether or not those proposed abatements are technically and economically feasible. a challenge that'll continue to require both the agency and employers to carefully examine that same question every time there's inspection or citation. But really, the best way to address it is at the inspection stage when answering inspector questions. Well, Taylor, that's a wrap. 30 minutes of another OSHA 3030 episode. Thank you, Taylor, for joining us. For those of you participating, you'll find all of our prior programs, including several on the general duty clause and quite a few on heat stress, on our library at khlaw.com/OSHA 3030. Check them out. And again, remember, when you get an invitation for the next OSHA 3030, please forward it on to 3 people within your organization and at other organizations, in the office of general counsel for a corporation or a safety and health professional who's responsible for compliance with occupational safety and health law. With that said, between now and when we see you again next month, please stay in touch with us through LinkedIn. If you're not linked into Taylor and me, please make sure you do so. Keller and Heckman's Workplace Safety and Health Law practice has another LinkedIn page, so link into that as well. And then subscribe to our podcast on your favorite podcast platform, and check us out on YouTube for any episodes you might miss, or you want to forward it on to a colleague. Let them know about it by forwarding on the YouTube link, and you can do so by searching on either OSHA 3030 or Manesh Rath. Both of them will get you to our podcast or our YouTube episodes. Our next episode, April 19th at 1 p.m. Eastern, always on a Wednesday, always at 1 p.m. Eastern. And when you get that invitation, please forward it on. We will look forward to seeing you then. Our sister programs, the TSCA 3030 and REACH 3030, are scheduled for April 12th, 2023. If your organization is responsible for compliance under those regulatory schema, please make sure you check out those programs. Well, that's it for this month's OSHA 3030. On behalf of Keller and Heckman, my colleague Taylor Johnson, and myself, I want to thank all of you for participating, and we look forward to seeing you again next month at the next episode of the OSHA 3030. And until then, stay safe.